Hi, everybody, and welcome to the second webinar in this series on responsible prosecution. My name is Jennifer Doliak. I'm an economics professor at Texas A&M and a senior fellow at the Niskanen Center, which is hosting these conversations. The goal of this series is to bring evidence to the often heated policy conversation on the role of prosecutors in the criminal justice system, as well as the effects of various policy reforms targeting prosecutors' behavior. So our focus here is on research evidence that measures the causal effects of prosecutors and related policy reforms. That is research that distinguishes correlation from causation. Always easier said than done. So we have a fantastic lineup of top scholars here. Again, in the second webinar, who are going to share their work with you in short presentations. I've asked them all to really put an emphasis on policy implications, given this audience. And so they're each going to have 10 minutes, short and sweet, to tell you about their work. And we're going to start with Orly Oos. So Orly, you can take it away.
Sorry, I'm going to try one more time.
No worries.
Perfect. Great. Thank you so much. So I'm going to tell you about some research that I conducted with Megan Stevenson from no longer George Mason University of Virginia Law School, asking whether cash bail deters misconduct. So a lot of the bail reform policy in the United States has been driven by questions about whether reducing reliance on cash bail will reduce pretrial detention. A lot of jurisdictions are thinking about this kind of bail reform. And one of the big concerns is that some defendants are in jail because they just can't afford to pay bail. And as we'll hear about, pretrial detention can have lasting consequences. However, incarceration is not the modal pretrial condition. So as an example, among felony defendants, about 2 in 3 were released before disposition, and 3 of 5 of these releases had financial conditions. While it's harder to get information on misdemeanors, the pretrial release is even more common for people who are charged with misdemeanors, and oftentimes there are also financial conditions. So what is the theory behind cash bail? Why do we even have cash bail in the first place? Well, the theory is that cash bail is supposed to act as a collateral to ensure that people show up to court, right? Basically, what you're telling people is if you do not show up to court, you will incur court debt. And so this puts a dollar tag, a monetary cost to failures to appear in court, which could act as a deterrent in itself. However, there could be costs of monetary bail for defendants who are released. So even for people who are able to post bail and not be in jail pre-trial, this could present financial strains to defendants and to their families or relatives or friends who have to come up with that money. And this may pose a larger hurdle for low-income defendants in particular. So in order to answer this question, does cash bail impact court compliance, which is, the reason why it exists in the first place? We study the no cash bail policy, which I'll tell you about in a minute, through which prosecutors said in Philadelphia, we are going to stop requesting cash bail for 25 low-level offenses in Philadelphia. So we're going to be using court records and compare what happens in terms of pretrial misconduct for those for those for whom prosecutors were no longer requesting cash bail versus those for whom nothing was supposed to change. So what is this policy? Larry Krasner was elected in November 2017. He took office in January 2018. And on February 21st, he decreed a policy where he said that he would stop seeking monetary bail for 25 low-level, which what I'm going to call eligible offenses, effective immediately. And so the list actually covered a lot of offenses. 60% of cases were eligible, and this includes both felonies and misdemeanors. The big difference was whether this was a violent crime or not. And you can see on the left-hand side, the majority of eligible offenses were drug offenses, However, violent crimes were not eligible to this no cash bail policy. So what we're able to do is look at changes in failures to appear and recidivism for those kinds of offenses that were on this prosecutor eligible list to trends in failures to appear and recidivism for those that were not on this list. And the advantage of this research design is that we're able to account for any other changes that were happening at the same time that would affect the eligible and ineligible offenses equally during the time period that we look at and at the pretrial phase. This is really the big policy that was happening, but this is a nice research design to account for any other changes in prosecution or police behavior. Okay, so turning to results. Oh, before that, pre-reform case characteristics. As I said, you can see that about half of eligible cases were felonies. And, even before this, this change in what prosecutors were requesting came to be, about half of the cases where defendants were already being released on recognizance, which means they did not have to post cash bail. You can also see that both failures to appear and recidivism were higher for eligible than ineligible cases. Likely, a part of this is probably due to the fact that people with ineligible offenses were more likely to be detained pretrial. But also this could raise concerns about cash bail actually being a driver of court compliance. Now moving on to results. First, I'm going to show you what happens to the fraction of people being released on recognizance, so with no pretrial conditions. So this is comparing trends in release on recognizance rates for eligible and ineligible cases. And you can see that there was a marked increase in release on recognizance. The second figure shows you that actually in our context, this did not translate into any differential pretrial detention. And so this is important because it means that it allows us to isolate the effect of cash bail on court compliance without any confounding effects of how pretrial detention may affect people's later outcomes. So again, think about this experiment as increasing release on recognizance, but so really changing the conditions of pretrial release. So what happens to pretrial behaviors? You can see that there was no change either in failure to appear rate or in recidivism rates. So summing this all together, this policy translated into an 11 percentage points increase in release and recognizance. That's about a 20% increase relative to the mean. No effect on pretrial detention, no effect on failures to appear or recidivism. And I do want to say that the average court debt was about $3,750. So this is how much a person would owe the courts if they fail to appear in court. And I do want to highlight this is not a small number since the median income in the zip codes that defendants came from was around $30,000. So we don't really think that the issue here is that this number was too small to act as a deterrent. All right, so finishing up with policy conclusions. So, the main finding here is that less pretrial accountability did not affect misconduct for many people. And so another way to say this is that many people could have more lenient pretrial release conditions without adverse consequences. And I think these are really striking results given current pretrial policies. Again, the big tool that most jurisdictions currently have in the United States to ensure pretrial compliance is cash bail. So this really feels like a large disconnect. And this is especially striking given the economic inequities in terms of access to in terms of access to this money and possibly the consequences of accruing this court debt. I think this research also has some open questions. First, note that this was prosecutor-driven pretrial reform. And later we're going to hear about another example, which was legislator-driven pretrial reform. And so one thing that I want to highlight is that prosecutors do not decide pretrial release conditions, bail magistrates do. So this is really inputs from prosecutors. And I think this raises questions in terms of equity and who benefits most from these policies. And then the scale of these policies, meaning, it's not the case that 100% of people with eligible offenses are now released with no financial conditions. And then, as we'll see when Alex Albright presents her research, possibly judges having some information which allows them to have these kinds of greater releases without any adverse consequences. And I think the second family of open questions is, what are alternatives that could be used to increase court compliance? So if cash bail is not effective and if financial incentives don't work, what are alternatives that can be used to increase court compliance? There is some research on that, which I think I will talk about in a couple of weeks, but of effectiveness of text messages. But this is just one piece of research and very much an open question as to what are ways and what are cost-effective ways to increase court compliance if people are going to be moving away from cash bail. Thank you.
Great, thank you, Orly. Next up is Crystal Yang.
Terrific. Thank you so much, everyone, for having me. And it's awesome to follow after Orly, since there's so many connections between what I'll be talking about and what she already talked about. So this is a past work of mine that's looking at documenting some of the causal effects of pretrial detention on a variety of different outcomes, not just criminal case outcomes, but also future criminal activity and also importantly, long-term employment. This motivation, I think, is probably not needed for this audience, but just to point out that pretrial detention is very common in the US and has increased somewhat over time. And part of that increase has, as Orly mentioned, been driven by the fact that we use pretty stringent release conditions, in particular cash bail or monetary bail. So one statistic, for instance, from some nationally representative data on felony defendants is that less than 25% of these felony defendants are released without some type of financial conditions. And those average bail amounts can actually be quite high, not just for felony defendants, but also misdemeanor defendants. In the setting that I'll study, which I'll describe in a moment, we're actually able to link defendants to their formal sector employment earnings prior to the time of arrest. And we find that for our average, both felony and misdemeanor defendants, many of them earn less than $7,000 a year in formal sector earnings prior to their arrest. And that could really explain why many of these bail conditions can be very difficult for defendants to meet, which means, of course, that they ultimately are detained pre-trial. So for instance, in our setting, we say that only 50% of defendants are able to post bail, even when it's set at $5,000 or less. And this is just one chart that I like, which really shows that the United States is quite a bit of an outlier in terms of pretrial detention rates. Here you see the United States to the very far right of this graph compared to, for instance, other OECD countries. Now, in theory, we all know that the pretrial system is supposed to be serving a couple of different goals and balancing them. It's meant to release as many defendants before trial as possible, but of course also meant to ensure both that defendants actually appear for court at their required court appearances, and also to prevent new crime and protect the public. I think this is what Orly refers, when she talks about court compliance and pretrial misconduct. There's been a lot of debate in this area. How well is this pretrial system actually accomplishing these objectives? And I think there's some consensus that it's not doing so well. Because of cash bail, for example, pretrial detention often seems not to be based on the riskiness of individuals, which might be better tailored to those objectives, but a result of poverty. And as I'll show you in some of this work and other work in this literature, we're finding that pretrial detention can be very disruptive and harmful in terms of long-lasting consequences for individuals who enter into this system. And of course, legally speaking, the DOJ has actually intervened in various class action litigation across the country to actually say that many pretrial systems are not only unconstitutional, but also just bad public policy. And so this is a space where I think there's a lot of interest in thinking about alternatives to the existing system, whether that's less reliance on cash bail, as Orly studied in Philadelphia, alternatives like supervised release, sometimes electronic monitoring, or also risk assessment tools, which I know you'll be talking a lot about in the seminar as well. So this project was actually really motivated by, I think, really valuable media attention to the problem of the pretrial system. This was a pretty famous bail trap article in 2015 in the New York Times Magazine, which really anecdotally told a lot of stories how even pretrial detention, even for just a few days, could be really disruptive and damaging to individuals who had that experience. Here's a particular quote from this article. This is a defense attorney who said that our clients work in service level positions where if you're gone for a day, you lose your job. People who live in shelters where if they miss their curfews, they lose their housing. Folks with immigration concerns are quicker to be put on the immigration radar. So when our clients have bail set, they suffer on the inside, they worry about what's happening on the outside. And when they get out, they come back to a world that's more difficult than the already difficult situation that they were put in before. So this project was really trying to causally study whether some of these anecdotal claims were actually happening in practice. And so what we did in this paper, and I think this probably relates to some past work that you already saw in last week's seminar, is to try to estimate the causal effects of pretrial detention, utilizing the effectively random assignment of cases to bail judges. In many parts of the country, bail judges are effectively randomly given different types of cases based on rotation systems to try to balance these caseloads across different bail judges. And because bail judges have a lot of discretion in what types of bail terms and conditions to set, this means there's actually quite a bit of variation, even within judges in the same court, about how often they detain an individual, how often they release, how often they use RO, for instance, release on recognizance. And this means that there's essentially some random variation in whether you might yourself be detained or released based on the judge that's assigned to your case, right? If you get the really lenient judge in a court, you're going to be more likely to be released pre-trial. And if you get a really tough judge who detains a lot of people, you will be less likely to be detained pre-trial. So we're going to use this type of variation in judge assignment and leniency to estimate the causal effect of pretrial detention on a couple of different outcomes. And I'll try to summarize at the end with sort of a partial cost benefit calculation to help us interpret what we find. So we're going to study two settings in particular, Philadelphia and Miami. They kind of have two bail system rotation systems that I think are fairly representative of many parts of the country. Philadelphia, for example, has these 6 full-time bail judges who basically their full-time job is to hear bail cases and make bail decisions, and they sort of shift every couple of 5 days. Miami is another type of system that I think is quite common across the country. There's kind of a permanent bail judge during the weekday, but on weekends, basically all the different types of judges, some bail judges, some trial judges, kind of rotate in to equalize caseloads and help out. And this generates some of that quasi-random variation in which judge is assigned to the case. Here, I just want to show you a histogram, if you look at this histogram, of just how much variation there is in what I call judge leniency, here measured as the judge propensity to release an individual. You can think about the 0 in the middle as effectively the court average, norm to the court average, and you see here that we have judges that are quite dispersed in their tendency to release or detain an individual, right? Some judges are nearly 10 percentage points more likely to release a person. Some judges are 10 percentage points less likely to release a person. And so that's kind of the variation that we'll be using for this study. What I've also plotted, and you see in this sort of upward sloping line here, is just the relationship between the judge that you're assigned in terms of their leniency and whether you yourself in that case are ultimately released or detained. And what you see from this upward sloping line is that the judge you get really matters, right? A judge that is more lenient, if you are assigned to that judge, you are also much more likely to be released pre-trial. And so again, that's sort of the intuition behind how we're going to estimate these causal effects of pre-trial detention. So we're going to link that criminal case data I have from Philadelphia and Miami to administrative tax records at the IRS, which will allow us to study formal sector employment as well. So let me just summarize here what we find in terms of these bar charts here. So if you take the sort of outcomes on the left here in dark green, these are the case outcomes in that individual's case, and the size of the bar represents sort of what we find as an effect, and that little sort of dashed line represents the confidence interval about sort of how sure we are about that effect. What we find in terms of case outcomes is that being detained for pretrial, even just for 3 days, substantially increases the probability that you're found guilty in that case. And most of that, as you see in the sort of the next green bar, is coming from pleading guilty. This is because oftentimes you really want to get out of jail, And so you plead guilty, a prosecutor might offer you something like time served, and so you plead guilty and you know that you're out right away. We actually don't find much of a huge effect on sort of additional incarceration post-conviction. It really seems to be a lot of cases that are pleading out potentially with time served. But of course, now you have the mark of a criminal record, which I'll come back to and think is really important. In sort of the middle panel here, we're going to actually look at pretrial misconduct, both in terms of future crime and failure to appear. What we see is that somewhat mechanically, as you might expect, being detained pretrial does decrease pretrial crime as measured by a new arrest for a different offense, and it also decreases failure to appear. On the other hand, we find this really important, I think, offsetting effect, such that if we look at new criminal activity as measured again by arrest, after the case is disposed of, we actually see an increase in future crime. This, we think, is a criminogenic effect of pretrial detention. And it's really important because if you think about the net effect of pretrial detention on crime, you actually get offsetting effects, both in the time period that you're detained, where we do see a fall in crime, but also then later an increase, which means we might not be getting the public safety benefits from a long-term perspective that we'd hope for from pretrial detention. Finally, if you look at the bar graphs on the right there in blue, we're going to look at future labor market outcomes. And we find in this paper that even up to 4 years after that original arrest, you're substantially less likely to be employed in the formal labor market and substantially less likely, for instance, to take up important safety net benefits like the EITC, which are tied to formal sector employment. And so these are sort of our main set of findings. What we then do is do sort of a rough cost benefit calculations where we take some of these things we're finding and try to quantify what this means for sort of a net cost or benefit of pretrial detention. For instance, among the costs of pretrial detention, something that's incredibly costly from what we find is the decreased total earnings to the defendant from this loss in employment in the long term. There are, of course, benefits such as decreased failures to appear, but if we sort of quantify what we find, we effectively find that unless there are really large deterrence effects of having a stricter or harsher pretrial system, there's a pretty big net cost of pretrial detention, right? It's pretty costly again because defendants really lose a lot of earnings in the long run. And again, because the public safety benefits are actually offset later on by these criminogenic effects of pretrial detention. So let me just then end with sort of policy takeaways. We really think the effect of going through the pretrial system and potentially being detained has really long-lasting consequences for defendants. And this is even for relatively short periods of pretrial detention for just, for instance, 3 days. We also find that pretrial detention is criminogenic in the longer term. And I think this is really important to consider because it suggests that the short-run incapacitation benefits we might get from pretrial detention may not be on net justified if we're thinking about longer term public safety. And again, based on these partial cost benefit calculations I showed you, our results really suggest that unless, again, there are huge deterrent effects to detaining individuals, releasing more defendants is likely to substantially improve social welfare. And of course, one of the channels of potentially doing this is through less use of cash bail, exactly the type of research that orally presented, which may not even have the effect on court compliance that a lot of people have, said that it does have. And here I think is my last comment that I'll make is that I think prosecutors can play a really important role here through the recommendations and thinking through alternatives to pretrial detention. So I will just end there and turn it over to the next speaker. Thank you.
Great, thank you, Crystal. Alex Albright is up next.
All right, thank you so much for having me. And I'm excited to be on this panel with so many people whose research I really admire. So I'll just say that up front. So my name is Alex Albright. I'm a research economist at the Minneapolis Fed. And I'm going to be talking to you today about a paper that I have that's about money bail reform and trade-offs induced by an automatic release program that was implemented in Kentucky a few years ago. Great. So just to start off, a bunch of people have already talked about this, but I'll just reiterate, incarceration before any conviction is quite common in the United States, right? So about 65% of people in US jails are in pretrial detention, and that's about 500,000 people in levels per day. And that's also a number that's increased about sixfold over the last 40 years. And we know that pretrial detention is quite expensive. So the jailing costs alone are about $15 billion. And we just saw some research in that previous talk about how pretrial detention also harms the legal outcomes and the labor market outcomes of detained individuals. And that's been well documented, not only by the previous paper we just saw, but by work by a variety of other panelists. So Emily Leslie, Megan Stevenson, and a few other people also have contributed to that literature. So one question then is, well, how do people end up in pretrial detention? And in the United States, we know that a big part of this is the bail system. So after arrest, bail conditions are set before conviction determinations. And the point of bail, the legal objective, is to ensure court appearance and ensure public safety. And in the US, usually when people say bail out or paying bail, or talking about bail in general, they're talking about money bail. And money bail specifically is when you have to deposit some sum of money for your jail release. And this is meant, as Orly was mentioning earlier, as a financial incentive. It's meant as a form of collateral. So you're more likely to appear in court if there's money on the line. That's the theory. And we also know, however, that money bail can induce pretrial detention. If you don't pay this money, if you're not able to, you can be put in pretrial detention because you're not able to meet that requirement. And so it's this large scale of pretrial detention that I mentioned earlier, that 500,000 people, coupled with the usage of money bail and money bail's role in pretrial detention, that has fueled a huge wave of bail reform over the last few years. So this is definitely not news to all the practitioners out there, but there's many states, many jurisdictions in the United States that have been reforming their bail systems. And there's tons of variety here in exactly how these reforms work and what exactly they're doing. Orly earlier talked about a prosecutor-led reform, but I think that the general theme here of these reforms is moving away from money bail. That's quite common across place. And also, even though there's variation across exactly what the reforms are, they do share common goals and concerns. The common goal is reducing pretrial detention is often the aim here. While the countervailing concern, and one that you'll see a lot in the media that relates to concerns about how cash bail reform is going, is, well, what is happening to pretrial misconduct? So misconduct in this case meaning court non-appearance, but also rearrest, so arrest for some other offense while out pretrial. And so it's that tension between detention and misconduct that I'm focusing on in this paper, okay? So the question is, what are the causal effects of narrowing the use of money bail? And then what is the trade-off that is induced, if any, between detention and misconduct? Now I'm going to tell you a bit about my setting. I think that this is a really unique empirical setting. So hopefully this is part of why this paper really adds to the existing literature. So this is a program called Administrative Release in Kentucky. And let me tell you a little bit about how it works. So before the program was implemented, judges were making decisions for all bail cases. So they had discretion in how they wanted to set bail, which is quite common. But after administrative release, what happened in the pretrial setting depended on case eligibility. Eligibility in this setting refers to whether the case is eligible for administrative release or not. So as you see with this little plot, basically, if the case is eligible, then actually the case is going to be administratively assigned unconditional release, which is just another word that I'm using for release on recognizance. So the most lenient type of bail. And so what this means is that there's some subset of cases that actually aren't going to see a judge at all. They're being sort of diverted away from judicial discretion and just automatically assigned release on recognizance or unconditional release. If a case is not eligible, it'll go to a judge as usual. I'll also note here that you might be wondering, well, what is an eligible case? How does it compare to what Orly was talking about earlier? In this case, the main factor for eligible cases is that they're non-sexual, non-violent misdemeanors. So these are lower level offenses like shoplifting or drug possession or public intoxication. I'll say a few other things that I think are notable about this program. So the automatic nature of it is very important here. So a lot of bail reforms and criminal justice reforms more broadly, I think, often rely on criminal justice actor discretion. So they might be a nudge for someone to act a little bit differently. So nudging away from money bail or cash bail. But in this case, the automatic nature is going to lead to really large effects, which I'm going to show you in the next slide. And the other thing that I'll highlight is this gives us what we call a natural experiment in economics. So that is to say the structure of how this program works actually maps really well onto methods that we have to try to isolate causal effects. So let me try to talk a little bit about that to make it clear. So what I'm showing you in this graph is I'm showing you the unconditional release rate for eligible and ineligible cases over time before this program, before administrative release is implemented. And what you should see here is that the trends are moving quite parallel beforehand. This is the primary identification assumption for something called difference in differences. And really what I'm saying here is that the ineligible cases serve as a nice control group for eligible cases, which are then going to be treated by this program. And here's what I mean when I say treated by this program. You should see in this graph that there's this big jump up for the green line. What that jump up is it's the administrative release program working. It's the administrative release program actually giving release on recognizance to these eligible cases in this automatic way. So this is the intuition behind how I'm actually getting causal effects from this program. And I'll also note, I think it's interesting that even these low-level cases that are eligible in the pre-period before this program, they are only getting release on recognizance less than 25% of the time. So you could have imagined that this program maybe wouldn't make that big a difference because maybe judges, even in its absence, were giving a lot of low-level cases release on recognizance. In this case in Kentucky, we see that that is not the case. So actually, the automatic release program has a really large bite in terms of changing bail conditions. So then how do these changes in bail conditions map onto those two objects of interest that I mentioned before, detention and misconduct? That's what I'll talk about now. So we had that 50 percentage point change in unconditional release and release on recognizance, right? What that ends up translating into is a decrease in total detention hours of about 42%. If you want to know what that is annually, so over the course of a year in levels, what that translates to is it's about 25 less person years across the population of interest. However, I do find that court non-appearance increases as a result of the program. So this increases by about 3 percentage points, which in levels is about 360 more court non-appearances. However, I don't find significant effects on pretrial rearrest. So I'm not finding strong evidence of a large increase in pretrial rearrest as a result of this program. And so after hearing this, you might think, okay, so I've learned that money bail went down a lot in this place. Detention hours went down a lot too. That's what was desired. However, there was this small increase in court non-appearance. So what do we make from that? Well, one option here is to just try to think about, well, do these effects constitute a justified trade-off? Under what assumptions is this policy desirable or not? And one way to do this is to take a simplified cost-benefit framework and just look at the relative changes. In that case, what we get is that this trade-off generated by the program is justified if one court non-appearance costs less than 26 detention days. So that's the main headline result that I'm highlighting here. The full paper also has some work on racial and socioeconomic gaps and mechanisms. So I'll direct you to the full paper if you'd like to learn more about that. For now, with the remaining few minutes that I have, I would love to just talk a little bit broadly about policy takeaways. So first of all, not all bail reforms and also not all criminal justice reforms of any genre are the same. This is quite clear, I'm sure, to all the practitioners out there, but I just really want to highlight the distinction between automatic and discretionary changes here. So it makes a really big difference if there's some sort of nudge to behavior where there's options to deviate, as opposed to a push like this, where we saw, again, a 50 percentage point change in bail conditions, which was quite striking. Another thing that I want to highlight is even policies that call to quote unquote end money bail are ambiguous in some ways. And what I mean by that is, what is the counterfactual, right? You could end money bail and have the alternative be that everyone is detained or everyone gets electronic monitoring, or you could have a world where ending money bail means some population gets automatic release, like in the case of Kentucky for eligible cases. And so the reason that this matters is because it really matters for our policy conversations to understand what are we saying takes the place of money bail when we're shifting away from that. And I think really similar comments as these apply to prosecutorial reforms, right? So like, how are those reforms implemented, and what's the counterfactual to prosecution when we're talking about non-prosecution? And then I'll bring up one last thing that Orly also mentioned earlier. So even though in this case we see slightly worse court appearance, that's not to say that then there's no alternatives to addressing court appearance beyond money bail, right? So there's work about text and phone call reminders. And then I think there's also some growing interest in even thinking about virtual attendance. So what does it mean to allow people to actually participate in their court appearances virtually, potentially reducing the cost of attendance to them? So that's one thing that I'll bring up right at the end here. Great. So thank you so much for your time. You can find more at my website, but thanks so much.
Great. Thank you, Alex. And next up is Viet Nguyen.
All right. Thank you for having me here today. I'm really excited to present this paper. It's titled Efficacy of Prosecutor-Led Adult Diversion for Misdemeanor Offenses. So there are many diversion programs. Some focus on reducing the amount of time spent in jail or prison. Others focus on addressing more challenging issues such as substance abuse, mental health, or unemployment. And generally, these later programs are much more costly and resource intensive. And there's been a recent wave of newer diversion programs run out of prosecutor's office that instead focus on reducing the footprint of the criminal justice system. There are a couple of common themes with these programs. One is, to minimize the amount of contact with the criminal justice system. The second is to hold people accountable, but albeit with a lighter touch. And the third is to use expungement to clear prior records or criminal records. And these programs are very much cognizant of the impact of collateral consequences and criminal records, especially with the expansion of digital criminal databases over the past couple of decades. And so in a way, these programs try to strike a balance between holding individuals accountable, but also providing people with a second chance. And if prosecutors are using this as a main policy tool and they're expanding, the natural question is, what is the efficacy of these second chance diversion programs, especially for the pool of misdemeanor offenses, which is generally the main diversion target? Can these programs maintain public safety? Can they increase the number of people exiting the system with a clean slate? And do they produce a net widening effect? And net widening is a general concern when people introduce a new diversion program. Essentially, the idea is that when you introduce a new sanction, it's going to draw in people into the system who previously would have been dismissed without their diversion option. And we're going to specifically look at Philadelphia's main diversion program, which is the Accelerated Misdemeanor Program, also known as AMP. This is a program that targets individuals charged with nonviolent misdemeanors who have no prior convictions in the past 10 years. And under this program, no pleas entered, and they're required to complete 12 to 18 hours of community service, pay any fines and restitution, generally within 5 to 10 weeks, which is a pretty quick turnaround time. Afterwards, if the individual is successful, the DA will withdraw the case and automatically petition the case to be expunged. So altogether, AMP serves as a less onerous diversion program, especially compared to what Philadelphia was using beforehand, ARD, which generally consisted of 6 months to 2 years of probation. So you're moving from a long probation term to just 12 to 18 hours of community service that can be completed quite quickly. So to study this program, we're going to look at about 4,000 misdemeanor cases opened between July 2009 and September 2011. And we're going to use a difference in design. We're going to compare the changes in outcomes for defendants who are eligible for AMP to those who are ineligible for AMP due to their current offense or their criminal history before and after the creation of AMP on July 2010. And because I'm only able to observe people's criminal history for the past 10 years, I'm going to restrict my sample to those who are between the ages of 18 to 27, where I can determine their eligibility for this new diversion program. So I'm going to start first with an examination of the changes in dispositions, and then I'm going to move to public safety outcomes, and then a more nuanced discussion of net widening. So this right here is a figure showing the changes in disposition for the comparison group. So this first vertical line is when AMP was rolled out as a pilot program, and the second line is when AMP was fully expanded. So as you expect, for the comparison group, which is always going to be ineligible for AMP, we should see no changes in dispositions, and this appears to be the case. So for that orange and gray line, those are cases that are sentenced to jail, probation, or dismissed, and the blue line are cases that are sentenced or sent to diversion. And the dispositions are the same across the 3 policy periods. But when we look at the treatment group, we see a huge uptick in overall diversion rates. That's that top blue line that happens right as AMP is rolled out. And at the second vertical line, we see that AMP becomes the main diversion realm. So that's the second blue line that's right below. AMP becomes the main diversion option once it's fully expanded. So now I'm going to move to difference in difference estimates. And these are bar charts that first show the mean for the treatment group in the pre-period. And then I'm going to add the difference in difference estimate in the orange bar. And this is a way to show both the estimate of the policy and be able to compare it to the pre-period group, pre-period mean. So we can see the relative change in magnitude. So prior to AMP, less than half of the cases were being diverted. And with the expansion of AMP, 2 out of 3 cases are being diverted. And this is driven primarily by the increase in AMP. So AMP is not only increasing overall diversion rates, but they're also changing people, moving them from supervision to a shorter community service sanction. And the next question is, if AMP is increasing overall diversion rates, what pool of defendants is it drawing from? And we see about a quarter of cases were sentenced to jail or probation in the pre-period. That drops by about 8 percentage points. When we look at the dismissal rates, again, it's about a quarter of cases in the pre-period, and it drops by about 13 percentage points. And this is indicating a net widening effect, right? This is a new diversion program that is pooling from both pools of cases, those who are sentenced to jail and probation, those dismissed, but it's pulling much more heavily from people who previously would have been dismissed. So more people are being involved in the system. Now, when we look at the expungement outcomes, we actually see something that's a little different, right? So about a quarter of cases were expunged in the pre-period, and it jumps up sizably by 18 percentage points in the post-period. When we look at these long-term recidivism outcomes, these are 5-year rearrest rates and 5-year reconviction rates. We see a non-significant reduction in rearrest rates, and we see an 8 percentage point reduction in reconviction rates. So this presents kind of a perplexing situation, right? Earlier, we saw that this diversion program was producing a net widening effect. But when we look at the expungement outcomes and we look at the recidivism outcomes, we see that there's an increase in expungement rates and there's a decrease in recidivisms. I think this study highlights the need for us to revisit the concept of net widening and how we evaluate diversion programs. So again, generally, the concern with diversion programs is that if we bring more people under formal social control, if they fail their diversion conditions, it's much more likely for them to be tangled up to the system, and it's going to keep them in the system much longer. But it really ignores what I described to be as a net narrowing effect, right? Diversion programs and different sanctions also have the ability for more people to exit the criminal justice system with a clean slate. So what's possible to have is to have a diversion program that brings in more people in altogether, but also helps more people exit the system without a criminal record overall. And I think this is something that policymakers and practitioners need to consider. They need to consider what diversion is alternative to. And if I look at this bar chart right here, this is the expungement rate conditional on being diverted or conditional on being dismissed. And in Philadelphia, during this study period, if your case was dismissed, your record wasn't expunged. And you put yourselves in the shoes of the defendant. If you want to go back and move forward for the expungement process, you have to go back to your defense attorney. If it's a private defense attorney, you're going to have to pay more legal fees. You're going to have to fill out paperwork, move the red tape, and navigate a complicated legal system. What AMP does is shifts the onus of the expungement process from the defendant to the prosecutor. When you have a prosecutor who's automatically petitioning to expunge the case, I think the judge is going to be much more receptive to accepting the expungement process. And so what AMP is doing is facilitating a higher expungement rate, i.e. a net narrowing effect. And so just a couple of caveats with the reductions in recidivisms. We talked about expungements. This would be one major mechanism through which recidivism is channeling through. But this program is also limiting the degree of interaction between the criminal justice system. It's shifting people from traditional supervision to community service. And there's also a group of people who previously would have been dismissed, and now they're being held accountable. All 4 of these channels could potentially lead to changes in recidivism. There's also kind of this caveat in that, the reduction in recidivisms could be a product of system changes, right? It's possible that you have prosecutors who are seeing people with a cleaner record and choosing not to pursue a conviction in the future. It's also possible that defendants, if they have a clean record, they're able to build more mitigating factors, to have a stable job, to have a family. And so if they come across the criminal justice system again, the prosecutor is going to need to weigh the cost of moving forward with that conviction against someone who has a lot of responsibilities. And this is two potential channels in which there are system changes rather than behavioral changes. So altogether, AMP demonstrates that second chance diversion programs can improve recidivism outcomes, as well as improve the number of people exiting the system with a clean slate. And diversion programs and sanctions, they vary in their net widening effect and net narrowing effect, right? So it's negative to have a program that just expands and brings everyone in and has a very weak net narrowing effect. But you could also have a stronger net narrowing effect that balances out a net widening effect. And these can be conducive to longer, better term outcomes. Okay, thank you.
Great, thank you. And last but not least is Mike Mueller-Smith.
Hi, everyone. Thanks for joining us. This has been such a great panel. I'm so impressed by how much research can be compressed into 10-minute slots. This is really very impressive. I'm going to try to do the best that I can to round this out and rise to the bar that's been set already. I'm going to be talking about a paper called Diversion in the Criminal Justice System, and this is a great segue from what Bea was talking about. So just to kind of provide a little bit of broader background, criminal justice diversion programs have been a growing strategy in the US for a while. I think this is, people come at this from two different perspectives. One is from kind of a progressive standpoint of wanting to minimize the potential harms that individuals who are justice involved face as a result of contact with the justice system. It also comes from just a cost management standpoint. The share of the population that has contact with the justice system has been going up. The number of people facing charges, or going to prison, a whole range of things that have been going up, yet there aren't really substantial increases in resources to manage that caseload. And so if we find ways to divert people out from progressing further into the justice system, that can help contain costs. So in 2013, this is just kind of an arbitrary year, there was a survey done. There are thousands of these programs that existed, and you can see kind of examples of this diversionary logic being applied at the police stage, the district attorney stage, at the court stage. What I'm going to be talking about in this paper is a court-based diversionary program. And one thing that you might think of in this context are specialized courts like veterans courts or drug courts. That isn't this specific application. This is more of a generic diversion program without special additional services being implemented, kind of no additional case management occurring. And so you could think of this as kind of a low cost diversion. So what's the study? We're looking at two natural experiments that occurred in Harris County, Texas, which is where Houston is located. The first one happened in 1994. The second was in 2007. And let me just take a step back and explain what you're seeing on these graphs. On the x-axis, which is where you see all of the dates, this is representing the day or the week that an individual either had their case filed or disposed. And on the left-hand side, you're seeing all of the first-time felony defendants between 1992 and 1996, and the average rate at which those caseloads each week received either a dismissal or diversion outcome. And then in the 2007 experiment, that's the same exact exercise, except looking based off of disposition week. Now, what you'll see is that there's this really sharp, immediate change that occurs on two specific dates, September 1st, 1994, and then November 7th, 2007, where in the 1994 case, we see about a 30-point reduction in the rate of using these dismissals and diversions in the total caseload. And in 2007, about maybe 18 to 20% percentage point increase in the rate of using these programs. Now, what explains this kind of very sharp source of variation? Well, in 1994, there was a broader penal code reform that happened that constrained the ability of prosecutors to use the threat of incarceration as an enforcement mechanism for these diversionary agreements, which I'll talk a little bit more about on the next slide. And so they kind of told the legislature after they passed this penal code reform that they're going to stop using diversion unless they changed the law. The law wasn't changed, so they just stopped using it. In 2007, it's a completely different story. where there was significant jail overcrowding happening in Houston, and there was a ballot initiative to expand the jail. Now, in the lead up to the election, there was a lot of kind of finger pointing at the court system itself as contributing to overcrowding in the jail, and that the courts needed to take responsibility for the fact that there was so many people being detained in local lockup. Now, on the ballot was this initiative to expand the jail. It, by a pretty, I think, a large surprise based off of accounts at the time, it didn't pass. And so what we see is this immediate uptick in diversion and case dismissal rates immediately following that outcome. And we interpret that as serving two purposes. One, it turned off the flow of people into the jail, but then also it helped the courts kind of respond to these criticisms that they're facing in the popular press, that they were responsible for overcrowding because the judges and district attorneys were publicly elected officials themselves. Now, what's nice about this source of variation is we can look at individuals who either had their case filed right before or after one of these shocks, or their case disposed before or after one of these shocks. And it's as good as random whether or not they were likely to have a high likelihood of getting diverted or a low risk of being diverted, which helps kind of deal with this issue of correlation with versus causation. Now, what do we mean by diversion? In Texas, this is an intermediate sentencing outcome known as deferred adjudication of guilt. And there are similar programs that exist across the United States, sometimes using the name court deferral, deferred prosecution, probation before judgment, filing agreements, or deferred disposition. In this specific context, which is a very large program in the whole state of Texas, this functions as a type of plea deal wherein defendants avoid a formal felony conviction if they satisfy the specific terms of their court agreement. In practice, these agreements operate very similarly to probation with community supervision and community service. And so an individual might have, 2 to 5 years of probation that they have to serve out. And if during the course of that probation, they don't have any future additional offenses, the case will be closed out and it'll convert into a case dismissal. Now, if they do happen to have another offense, then that deferred adjudication then can have an updated disposition status that then becomes a felony conviction, and they can be sentenced again to incarceration. Now, an important thing to know about deferred adjudication in the state of Texas is that by the ruling of the Texas Supreme Court, if an employer asks about felony convictions, if you're subject to one of these deferred adjudication agreements, you don't have to report that on your employment applications. And so this could help individuals potentially avoid some of the stigma attached to criminal histories when they've had justice involvement at the felony level. And an employer might not be, might have concerns about hiring them, and might help them navigate that process. All right, so how did these changes impact recidivism rates? This is replicating that same exact figure that you just saw, but now instead of showing the case dismissal and diversion rates on the y-axis, I'm taking those same caseloads and showing the total number of future convictions that they have in Harris County over the next 10 years. And if you remember from the last graph, the two kind of sections on the outside of the graph, before September 1st, 1994 and after November 7th, 2007, those are the times in the caseloads that were subjected to higher rates of diversion. And what we see here is that they end up going on to commit lower total numbers of future convictions over the next 10 years. And that those defendants who just by risk of when they were charged or disposed faced a lower likelihood of diversion ended up having higher recidivism rates. Now, this is just one outcome. We find very similar results when we look at statewide convictions, charges versus convictions. Instead of counting up the total number of convictions, looking just at if you have any. The same is going to be true for felony versus misdemeanors, as well as different types of offense types. Now, a very similar story is going to occur for employment. This is showing the exact same exercise using average quarterly employment rates. And we see again that although these are going to be noisier outcomes because there's more variability in this outcome, that those defendants who by luck of the draw, they ended up facing charges or having their case disposed when there was a higher likelihood of diversion, they end up going on to have higher labor market engagement. And that's also true for earnings, durations of continuous employment, like if we have concerns about churn or finding new jobs after unemployment spells, as well as finding employment in industries that have lower historical rates of hiring those with felony convictions. Now, when do these impacts arise and are they sustained? Here, what I'm showing you is the impact of diversion. So I'm showing basically the gap at the discontinuity when these policy changes go into effect, and scaling by the number of defendants that were actually impacted by the policies. And this is just for the 1994 experiment, because we have the liberty of, or the luxury of, following these individuals for up to 20 years, which is pretty incredible. And here what we see is that the largest amount of gains for recidivism are occurring over the first 5 years, although you'll notice that there still continues to be drift even 20 years out, that although the marginal gains are smaller, there still do appear to be gains in terms of lowering future recidivism over the 20-year follow-up period. For employment, it seems to be a lot more linear. There definitely are strong gains over the first 5 years, but there's still strong gains years 15 to 20 years out, and which I find to be quite striking. This really is an opportunity to fundamentally change these people's lives. Similar patterns are observed for the 2007 experiment, but we only can show it for 10 years, given the data we had at the time. Now, we have additional results in the paper. We find these positive impacts are concentrated among young Black men. We find that it's basically the same group that's experiencing lower recidivism patterns are the ones who are also appearing to benefit on the labor market. Diversion avoids additional future incarceration and probation spells because of the fact that they have lower recidivism rates. And so there's kind of a widening of the gulf between those who weren't diverted versus those who were as they progress through time. So that's an additional source of cost savings. But we don't observe any of the benefits of diversion amongst those who are already holding a felony conviction. So our main analysis sample is just first-time felony defendants. When we have a smaller sample, but we have some who already hold a felony conviction, and we don't see any additional benefits for those folks. So in summary, in terms of thinking about the policy implications, diversion, specifically through a court deferral, is associated with very large decreases in offending, as well as improvements in labor market outcomes. Additional benefits seem to accrue even 20 years out, which is incredible. The stigma of a felony conviction appears to be an important mechanism, something we talk a lot about and do even more work to kind of digest in the paper. Our cost-benefit analysis, or as I like to call it, benefit analysis, because diversion is cheaper than you kind of practice as usual, and generates cost savings, suggests large contemporaneous and long-term savings resulting from this intervention. It's a good strategy for first-time felony defendants. And one thing to emphasize here is these are programs that are basically being used for property and drug defendants. It would be very rare that somebody with a violent background would be offered diversion. And so we just don't know whether or not this would be an effective program for that population. It's uncertain how to improve the outcomes for repeat defendants, though, based off of this. We just don't have evidence to speak to that. And that's all I have. So thank you very much for joining us today. And I will turn it back over to Jen.
Great. Thank you, Mike. Thanks to all our panelists for the excellent presentations and also for staying on time. I appreciate both very much. Thanks to everyone for being here. You can join us the same time next week. Register wherever you registered for this webinar, and we'll have another panel with another set of great research presentations. And the videos of these should be online sometime soon so that you can rewatch your favorites and send them to your friends. Thanks again, everybody. Have a good day.